So we have looked at the creation of treaties, the principles governing the application of treaties, and now we will focus on validity and termination, suspension of treaties. Starting with the topic of validity, the Vienna Convention on the Law of Treaties provides a categorization into two types of defects of faults that might lead to the invalidity of a treaty. The first set of reasons are what I have called here curable diseases. So a treaty might be invalid if the circumstances that are listed in the Vienna Convention on the Law of Treaties in Article 8 and 46 to 50 are present, but the state that is concerned with these faults, if you want, can decide to ratify the treaty anyway, to heal the treaty, and you can still have a valid treaty. This is the case of treaties that have been concluded with a manifest violation of provision of domestic law as regulated in Article 46, or concluded by someone who manifestly didn't have the powers, the full powers required to conclude the treaty or to provide the consent to be bound by the treaty. There's also a possibility that the treaty has been concluded by mistake. It has to be a serious mistake, the kind of mistake that would have meant that if you knew about it, you would have not consented to be bound by the treaty, or it can be concluded when fraud is present. From the way the provisions on validity are drafted in the Vienna Convention on the Law of Treaties, as well as from case law, it is clear that the validity of a treaty has to be presumed, both when there are allegations that the treaty is invalid due to causes that can be rectified, as well as when the treaty is claimed to be completely void by reasons, as we will see, that are not curable, as I have called them myself. So I have here a couple of examples. For instance, the case between Cameroon and Nigeria that was pending before the International Court of Justice between 1994 and 2002. One of the issues under dispute was the validity of the Anglo-German Agreement of 1913, by which the British were giving away, was a treaty of cession of the Bakassi Peninsula to the Germans. Okay, so it was claimed that this treaty was not valid. This was claim made by Nigeria because the treaty had not followed the steps necessary to enter into force. In particular, the treaty had not been approved by the German parliament. This was not accepted by the International Court of Justice. Another example that illustrates the reluctance of the International Court of Justice to conclude on the invalidity of a treaty is provided by the Temple of Prayer Viher case that was decided in 1962. This is a case between Cambodia and Thailand. And again, one of the issues under dispute was a treaty. In this case, the treaty was, first of all, the existence of the treaty itself was questioned by Thailand, that at the time of the conclusion of the treaty was Siam. It was a series of, it's a treaty containing several maps between Siam, then Siam, now Thailand and France. And first Thailand claimed that this was not really a treaty, that was dismissed by the International Court of Justice. And then it claimed that that treaty that contained the boundary by which the temple would fall within the jurisdiction of today's Cambodia was a mistake, that Thailand, then Siam, had approved, have agreed with that map by mistake. This was not accepted by the International Court of Justice. The Vienna Convention on the Law of Treaties also lists a number of reasons that will make a treaty invalid, but on this occasion, these causes cannot be repaired. The state cannot remedy the faults that are present in the treaty. This is the case of treaties that have been concluded with coercion on the state representative or corruption of the state representative that has concluded the treaty, or also coercion on the state itself. In addition, the treaties that are contrary to a peremptory norm of international law are also void and have no legal effect. Several examples demonstrate the little impact of these provisions in practice, and in particular in the jurisprudence of the International Court of Justice and its tendency to just presume the validity of treaties. So the first example concerns the territorial dispute between Libya and Chad. This was a dispute over the Ozo Strip. It's in the middle of the Sahara Desert and has a few thousand inhabitants that are the Tubu people. This territory had been for many years fiercely disputed between Libya, since it became independent from Italy in 1951, and Chad since its independence from France in 1960. This case ended before the International Court of Justice, and one of the allegations of Chad, of the claims of Chad, relied heavily on a treaty between Libya and France, where France had included its former colonial borders, and according to those borders, the Ozo Strip will belong to Chad. In this context, Libya claimed the invalidity of that treaty between France and Libya, among other reasons, because according to Libya, this treaty had been concluded with coercion from France over the king of Libya. To be honest, you can say that many treaties have been concluded, particularly between former colonial powers and colonies, with overpowering domination from one side over the other. The International Court of Justice didn't accept this argument. Most peace treaties where one party has been defeated will also be theoretically concluded with coercion of one part over the others. There is a whole discussion at political level and also scholarship on whether coercion included only the use of armed force. This is one of the problems of interpretations that we were talking about in the former session. It's been accepted in general that coercion does not include political or economic coercion. A treaty is valid despite the fact that the parties might not be equal in strength and in the negotiation stage. However, it is in principle invalid if it has been concluded as a result of the use of armed force. However, since most peace treaties will be invalid according to this, it seems to imply that this will only be the case of treaties that have been concluded after an illegal use of armed force. For what matters here, in practice, it is impossible to find examples where a treaty has been declared invalid based on coercion, despite attempts to claim that ground. Also, it is widely accepted that treaties concluded or any agreement contrary to a peremptory norm of international law is invalid. However, the International Court of Justice has been very reluctant to accept this as a ground for declaring the invalidity of any agreement. In general, the International Court of Justice has been reluctant to use the category jus cogens and only refers to them in one case on armed activities on the territory of the Democratic Republic of Congo. In at least two clear occasions that we will look into during our sessions. The International Court of Justice had a clear opportunity to declare treaties void as a result of their conflict with the right to self-determination. This is the Western Sahara case in 1975 and the Chagos case in 2019. In addition to circumstances or facts that may affect the validity of a treaty can also be terminated or suspended if the parties of the treaty so desire. Okay? Some treaties will survive any desire of termination. That's probably the case on any treaty setting boundaries, but the treaty can always be terminated by agreement. You need to look at what the provisions of the treaty say about issues such as withdrawal. Specific provisions of the Vienna Convention on the Law of Treaties also look into the issue of withdrawal and reflect conflicting views that exist in a scholarship on whether or not it is possible to withdraw from a treaty that remains silent on the topic. So you will have authors who claim, obviously, you can always decide to become party of a treaty, you should have the same power to leave a treaty. Others will make a distinction between treaties that are based on reciprocity and this categorized as contract treaties, and the others which are lawmaking treaties, establishing that only the first ones are by their own nature withdrawable, if you allow me the expression. In practice, states have withdrawn from treaties, and it is presumed they can withdraw from treaties. So you can also have a termination of a treaty that only affects one state but not others, if it's a multilateral treaty that is withdrawn by only one or two states. The treaty itself might have an expiry date and establish its own end. It can be that the treaty is approved for a particular project, like the construction of a particular infrastructure on an international river, and once this project is completed, there's no more reason for the treaty to exist. So even if there is no particular agreement of termination, you will consider the treaty completed and finished, terminated. The treaty might become obsolete after years and years of not use and not relevant to new circumstances. So there's different ways a treaty can be terminated by agreement or by the will of some parties of the treaties, or because the object of the treaty, the nature of the treaty, so suggests that the treaty is finished or suspended. We will look into another specific case that is good to look at other reasons to terminate a treaty when one of the parties is not fulfilling its obligations. So states can also terminate a treaty when they think they consider that the other party or parties of the treaties are in breach of the provisions of the treaty. We will look into these causes through the Garchikovo-Nagimaros case, a conflict between Hungary and Slovakia with many geopolitical connotations, and we'll look in particular to the reasons that are established in the Vienna Convention on the Law of Treaty: material breach, supervening impossibility of performance, fundamental change of circumstances, one of the topics that has been also discussed in the context of Brexit, and the existence of a new peremptory norm of general international law. As we will see in that case too, even when very extraordinary circumstances are concurring, the International Court of Justice has not been willing to accept reasons to terminate a treaty, and has clearly shown a preference for the continuity of treaties There's also a couple of provisions that we are not going to look into because they have actually never been used to terminate in treaty, but are outlined in Articles 65 and 66 of the Vienna Convention on the Law of Treaties.